Okay, and good morning. Welcome to the LSU Law Journal for Social Justice and Policy's third annual virtual symposium. My name is Tom Galligan, and I'm a professor here at the LSU Law Center, and I'm lucky enough, along with my colleague and friend, Professor Susan Tanner, to be the co-advisor to the journal. Now, the LSU Law Journal for Social Justice and Policy is a student-edited academic journal based at LSU's Paul M. Hebert Law Center. The journal was founded in the fall of 2019 by students who were interested in promoting the discussion of important issues relating to social justice and public policy, and they wanted LSU Law to have a meaningful voice in those discussions. Now, those two founding students were Sophia Biriel Sanchez and Raven Mouton. I was the dean at the time, and they came to my office and suggested the creation of this journal. I hope I seemed as enthusiastic as I was, because they left my office that day, they took the idea, and here we are today, and I couldn't be prouder. The mission of the journal is to reach current and future members of the legal profession with fresh perspectives on controversial issues relating to social justice and policy, and to address a gap in the types of matters explored in the academic legal writing in general and at LSU. Today's program is about and is titled The Industrial Prison Complex. It is about the system the United States has created and uses to incarcerate people. In America, the singer-songwriter Randy Newman says, "We have food to eat," but we also have almost 2 million people in prison, 629 people per 10,000, the highest rate in the world. 25% of the world's total prison population is in the US, and the highest rate of all is in our home state of Louisiana. And how many we incarcerate tells us nothing about the conditions of our fellow Americans who are incarcerated. Many of them are in America's almost 160 private prisons. Today, we will hear from 5 presenters regarding their research in this area, focusing on the prison industrial complex. The first panel you'll be hearing from includes Paul Finkelman, who is the Rydell Visiting Professor at Gustavus Adolphus College, and Paul will be going first on that panel. John Dacey, who is the founder and executive director of Abolish Private Prisons, and Robert Craig, who is the associate director of Abolish Private Prisons. They will be discussing the business and constitutionality of private prisons. Next, you'll hear from Brittany Deach, an assistant professor of law at Capital University, who will speak about pay-to-stay statutes and private prisons in general. Lastly, you will hear from Stevie Leahy, an assistant professor at Northeastern Law, who will speak about the aftermath of Jones and disparities in juvenile sentencing. Before we begin, let me thank the journal's production editor, Hannah Turner, the editor-in-chief, Amber Lee Nix, all the staff members at the journal, our moderators today, and once again, my co-faculty advisor, Susan Tanner, for helping to put together this year's symposium. Now, if you have a question, we ask you to please use the chat function, and the moderator will relay your question to the appropriate speaker. Now, I want to turn it over to the moderator of our first panel, my colleague, Jack Harrison, who is a great lawyer and a great colleague and faculty member in our juvenile defense clinic here at LSU. Jack, it is all yours.
Thank you, Professor Galligan, and welcome everyone to the symposium and to this first session. And we've got As Professor Galligan mentioned, we've got Paul Finkelman, Robert Craig, and John Dacey, and hopefully Mr. Dacey will be able to get on. I understand there may be some technical difficulties, but I'm hopeful that he will be able to join us very shortly. So I'd like to ask our guests this morning, our speakers, to first assist in some introductory and opening remarks. And so first I'll ask Mr. Finkelman. Mr. Finkelman, you've so far had a highly successful career in which you've written extensively on a wide range of compelling issues, and of particular interest to us here today on issues of race and slavery in American law. You've also spoken on these issues internationally, and I wonder if you have some thoughts on how our American views on human rights abuses abroad might inform an introspection and greater understanding of our own practices.
Well, the United States is often in the lead in moving towards greater human rights overseas and abroad. I think our support, for example, of the Ukrainian people is a good example of that right now. At the same time, we are not so very good at being introspective and looking at what we're doing in this country. And that leads to a kind of a contradiction. As Tom Galligan just pointed out, we have the highest incarceration rate in the world. Now, it may be that our incarceration rate is the highest because we are more accurate in our reporting in some countries, but that's a kind of a nonsense response, because if it turned out we had the second highest incarceration rate or the third rate, so what? It's an outrageously large number of people who are in prison, many for things that in other countries you would not go to jail for. And so we need to figure out how to stop this. And quite frankly, this panel goes to one of the problems, which is that incarceration has become very profitable for some industries, for investors, for some people. And so we have, in a sense, monetized incarceration for those who are willing to invest in private prisons. And that is simply wrong. And it leads to the problem, which I'll talk about later, of making imprisonment, incentivizing imprisonment for lots of people.
Thank you. Thank you. And now, by way of introductory moment, I'm going to go to Robert Craig, who is here with us. Mr. Craig, you taught fifth grade for 2 years, and you developed an interest and a passion for working with underserved communities and individuals. For the benefit of our student participants today, how did you carry that experience and passion with you through law school, and how did you carry that worldview with you into your career?
Well, first of all, thanks for having us. We're always happy to get a chance to talk about, the work that we do and how we see it as important to the, fitting into the broader criminal justice reform movement that's finally having at least a bit of a moment these days. So thanks for having us. As far as my personally getting to where I did and sort of carrying that worldview, I think that moment of teaching, I got to experience sort of firsthand what it looked like when people didn't have the systemic advantages that now I have language for. I think even when I was teaching, I didn't have quite the language to think about privilege and systemic racism and all of that stuff that I've learned, in the last decade or so. So took that, and going to law school, I was lucky enough to get a public interest fellowship when I was at Penn. And that was really crucial because apart from the monetary thing, what it really fueled was a group of people that all had an interest in working, using our law school education to make an impact in different ways. And I still keep in touch with that cohort of people. They've all gone on to do amazing things in a really broad array of spaces. And I think it was important because, it's very, very easy in law school to lose sight of what you wanted to do when you made the decision to go to law school because of the way that the system is set up. You have these summer internships, and the most common summer internship you get is with a firm. You end up with these student loan debts, and the most accessible way to pay those back is going to work for a big firm. And there's an issue where you sort of get trapped into that cycle. And so I think a really important thing to do if you have an interest in working in some way to make the world a better place is to surround yourself with people who have that same interest that can sort of bolster each other. It's really important to, when you're getting out of law school to find a job, it's who like where are people getting jobs? Where are there openings? It's just important to have that network of people and make sure that that network of people is doing things that you want to be involved in. And I think that's the most important thing moving forward.
Thank you. And I believe we have our third panelist joining us now. I believe he's been able to sign on. Mr. Dacey, John Dacey, are you with us? All right. I believe he may be with us and may be having some issues with the audio. So I'd like to get you all, I'd like to hear from you all, and I know our participants would as well. And I'll just open up the first question. Many aspects of our American criminal justice system cry out for reform. Issues surrounding conditions of confinement, solitary confinement, issues about the incarceration of young people, and of course, the death penalty. So why focus on private prisons? Mr. Finkelman, you can start off with this.
Yeah, so let me start off in two ways. First, my argument, which will appear, I believe, in this journal as an article, is that the idea of private prison violates the 13th Amendment. And the reason it violates the 13th Amendment is because the 13th Amendment prohibits treating people like property. That, in essence, is what slavery has always been about. There are many ways to define slavery. There are many cultures that have had slavery that differ in fundamental ways. But the fundamental theme of all slavery is that slaves are people who have been commodified and turned into property and bought and sold and traded and given away and owned. And that is a theme that runs across the world and across time. It is worth noting that there has been slavery in almost every known society from the ancient world until really into the 20th century. And we forget that in 1942, there were more people held as slaves. And this excludes people in death camps, but there were more people held as slaves in Germany in 1942 than there were in all of the Americas in 1860. And that's because Germany reintroduces slave labor as part of the Nazi regime. So slavery has always been with us, and it's always about commodifying people. So today we have private prisons. Private prisons work by relieving the state of the obligation of running their penal institutions and simply paying the private prisons to do this. This means that the people who own the private prisons, the stockholders, the management, have an incentive to keep people in prison as long as possible and to lobby as they do to create new laws to incarcerate more people. So this is exactly the opposite of what a rational penal system should do. A rational penal system should be one in which you help people who have broken the law reform themselves, become reformed, do their time, get time off for good behavior, and come out with job skills, come out with education, come out with those things which will allow them to succeed in the world. I'll give you one really quick example. In New York State, there's a maximum security prison at Coxsackie, which is just south of Albany, where prisoners are trained to do all kinds of construction work, including remediation for various things which are dangerous. And so they come out of prison with a prison record, and they get jobs at $50,000, $60,000, $70,000 a year doing construction remediation because they learned how to do it in prison. That's what we should be doing in prisons. We should be preparing people for the outside world. And we don't do that in a private prison because the private prison has no incentive whatsoever to prevent recidivism, to get people out early. All of its incentives are to keep people in prison. So that's why we're here today. Private prisons are a huge problem. And yes, the death penalty is a huge problem. But if we think about the number of people executed compared to the number of people in private prisons, the numbers are hugely different. And private prisons, I think, are an area where all citizens should, if they are educated, oppose, because private prisons are far more costly to the taxpayers than public prisons. So let me stop there and let you go on.
And I can follow up a little bit with that if that's all right. I think Professor Finkelman does a really good job nailing a lot of the problems that we have with private prisons, you know, from the fundamental incentive problems that is theory based to the actual, you know, how we see that theory get implemented into the real world. The final bit that I'd like to add on to that is continuing with the numbers theme at the end there. At Abolish Private Prisons, we work with a lot of criminal justice reform organizations that are doing other work, right? And one of the questions that we get asked all the time is why private prisons instead of you know, state-run facilities, or why not focus on all the different ways that value is extracted from people that are in public facilities by private companies? Because you know, there's a good point that approximately 10% of people that are in prisons in the United States are in private facilities. That number varies wildly state to state and the federal government. So it's not the biggest chunk of people. So why aren't we focusing on that other 90%? Our point is that there is so much money involved in private prisons, the operation of private prisons, that they turn around and use state taxpayer money and federal taxpayer money that they get from the government to operate those facilities and use that to lobby for increased sentences. They lobby and make campaign contributions to keep the system as it is today. They will tell you until they're blue in the face that they're not doing these things. They say that they don't participate in the lobbying to make criminal justice laws. It's simply false. There's lots of reporting on this. They spend a lot of money making contributions to campaigns, and it just like a rational person would ask, like, why are you contributing to campaigns if you're not hoping to get a business benefit from that? Because 2 of the 3 largest private prison companies are publicly traded, so you can look to see what's going on with those companies. And you know, because of Open Secrets and other organizations like that, we can see who they're donating to. So our point is, if we can get rid of private prison corporations, that will lead to more systemic, more data-driven, more expert-focused reform generally. We want to make sure that the people who are making those decisions don't have a vested financial interest in keeping people in prison longer, in making them serve their entire terms, and not using all of the alternatives to incarceration that research shows is better for the community and better for those people. So really, our idea is get the private prison corporations out of there so that experts and data can lead, and humanity really can lead the idea about what should a justice system look like, and it shouldn't be based on profit.
Okay, so I hear the idea of getting the private prisons out of there. Can you give us a little background on how they got in there in the first place?
Well, I'll start with some really deep history, okay? Starting in the 1500s, if we can get in our time machine, our Wayback Machine, and go back a long ways, the English developed what was known as the workhouse. And the idea of the workhouse was that if you incarcerated somebody, you would send them to work. And so at night they would go back to the jail. During the day they would work, because the belief was that the reason people went to jail is because they were vagabonds, because they didn't have jobs, because they didn't have a work ethic, and perhaps because they didn't know how to work or they were lazy. And so the notion was that the workhouse is a way of training people to be workers. Now, eventually, this morphs into prisons where you have prison farms, where you have prison factories, and where prisoners work in their prisons. And some states monetize this, make a profit from it. But prisons are expensive, and prisons become increasingly expensive as you get more and more prisoners, as the prison population grows. And so it becomes too expensive to build new prisons because the monetization of the prisoner through even a work system, such as in Louisiana, isn't enough. And so I think that is the origin of moving to private prisons, where companies say, hey, look, give us the money, we'll do the job, we'll be more efficient. We will maybe even do it a little bit less than what you're doing it for. But, and this is one of the catches here, if you're running a state prison and you have a budget for food, you have to spend that budget on food. If you're running a private prison and you can cut back, maybe you cut back 50 cents a day on every prisoner on how much you spend on food, that becomes an awful lot of money for the stockholders. That becomes incentive pay for managers. That becomes the money that you can use to lobby for more laws to keep more people in prison. So that's how the system develops. But I think Robert probably has some more modern insights. I'm, after all, coming here mostly as a historian.
Yeah, but I think what I find, interesting about this sort of tracking the historical growth of private prisons is they simply didn't exist as we know them today until very recently, right? You can look at sort of previous iterations of extracting value from people that are in prisons, right? And I think of the story as being deeply interconnected to the Industrial Revolution, because you have this transition of people making, laboring in the fields and largely agricultural, to needing all of these job skills to function in this industrial society. And you have capitalists who saw a lot of these people that didn't have skills and saw them as cheap labor sources, right? So that's when you start to see the workhouses. In New York, you start to see New York is a very interesting example of some of the very first interaction with this on a large scale, because in public run facilities, they would have, business owners come in and they would set up a factory inside the prison floor. So you would have like textile mills that were inside a prison, and the abuses of the prisoners were rampant. But I think that tying it to Industrial Revolution, you can really see where then you start to see the labor, the value extraction happen. And then as we move, and so that's where I start to see the connection between privatization of the labor force, but not really private prisons per se, at least until we start seeing the corporation run private prison facility. And that happens concurrent with the war on drugs, the war on poverty. You have this, like, in the late 70s, early 80s, what happens is the incarceration rate in the United States starts to skyrocket, right? The United States was not exceptional when it comes to incarceration rate compared to other countries until around the later half of the 20th century. And it was really this explosion of incarcerated people that allowed this business opportunity to develop, and they grew almost in line with the prison population. So the numbers are crazy. The amount of people in private prisons went up like 1,600% between 1980 and like 1995 or something. So there was just this huge explosion of privately run facilities. And the pitch that Professor Finkelman was mentioning was, we can run these more cheaply for you, and we can give you the flexibility to operate these very quickly. You can spool up a private run prison pretty quickly, because the more flexibility of the private business. That's a pitch, at least. We don't think the data bears that out, that it's any cheaper or more flexible, but that's a pitch that they make to legislators. And so they use the increased population of people who are incarcerated to really build that business.
Let me just add one more thing. The first system of private prisons in the US actually occurs in the South before the Civil War, because people create private jails for slaves. And so if your slave has misbehaved and you are too squeamish to personally punish your slave, you simply send your slave to the private jail, you pay the jailer to incarcerate the slave and perhaps to whip the slave every couple of days until you feel that the slave's been punished properly. Similarly, slave traders, and of course, the system of slavery in the US is one in which literally hundreds of thousands, many hundreds of thousands of people are moved from the East Coast to the Gulf states. Louisiana is a major recipient of slaves from Virginia, North Carolina, South Carolina, Maryland, Kentucky. Those slave traders all have private prisons where they incarcerate slaves as they buy them until they can move them further south. So if we want to look at the earliest history of private prisons, it's pretty awful because it's tied directly to the slave system. I want to add one more thing to what Robert said as well. The private prison says we can do the job for less. And if you think about that, even if it were empirically true, that must mean that it is either paying its prison guards less, which means they are less skilled. It is not training their prison guards the way they would be trained if they were trained at a state institution. They're giving the prisoners less educational opportunity, less food, less recreation. In other words, everything is being downsized, and the revenue that the prison company is making is a result of simply doing it on the cheap. And if the state has an obligation to treat prisoners fairly, to feed them fairly, to educate them, to prepare them, private prisons have no incentive to do that. Every nickel they can save is nickels that go into the pockets of the shareholders and the executives.
And by the way, all of that is factually supported by evidence, that researchers and academics have found. They do pay people less, the prison staff, they do provide fewer opportunities, the rehab facilities and the education facilities, and the food is worse. So all of those things that Professor Finkelman is talking about in theory is supported by the evidence. And I just, one final thing on this, because it's just is so crazy. I can understand walking into like an Apple store and being like, we can run this more efficiently. It doesn't need all this space and the beautiful tablets, and you can run a more efficient business or something like that. But to walk into a public run facility, right, and say, you know what, we can cut costs in here somehow is just baffling to me, because anybody who's been inside of, the vast majority of public run prisons knows that they are horrible places that are, they're inhumane the way that they treat people in there. So to look at a situation like that and think, yeah, we can cut costs there by making it even worse is just one of the most like barbaric thoughts that a person could have.
Thank you. And we now have joining us Mr. John Dacey, and we've been able to address those technical issues. So, Mr. Dacey, in 2015, you founded Abolish Private Prisons, but I believe that only 4 years before that, you didn't even know private prisons existed. What opened your eyes to their existence, and at what point did you begin to appreciate the extent of the problems inherent in the use of private prisons to incarcerate individuals? Can you tell us about that experience of first learning about a problem and then deeply immersing yourself into the work of addressing that problem?
Yeah, thanks, Jack. Can you hear me okay?
Yes.
Okay, sorry for the late arrival. Technology and I don't speak the same language. So I'm an old legal aid lawyer. My first 12 years in practice, I worked for nonprofit legal aid and public interest law firms, and some of that work included corrections work. I did federal class action work involving the Yuma County Jail in the western part of Arizona over horrible conditions. I mean, it was 130 degrees in the living quarters at times. So I had some background in it, and in 2010, I'm sorry, I took a 6-month sabbatical from my practice at a private law firm and deciding what I wanted to do next. And part of that discussion, a federal judge in Tucson, who used to be one of my legal aid colleagues, asked me if I would consider mediating prisoner lawsuits against the Arizona Department of Corrections over things like medical care, safety, religious freedom, and the like. He knew my background. And I said, if you'll help me remember what I used to know about jail and prison law, I'll start reading headlines to catch up. And sure, I'd be happy to do this. That's the first time I ever read the words private for-profit prisons, and at a visceral level, it just felt like, oh no, this is a really bad idea. This is the government's responsibility. This is a core responsibility. The more I read about prison privatization, the more I became convinced this isn't just a bad idea. This is a new variation on how we enslave people. This is how we control people of color, and this is how we extract value from the underserved. And so I decided then to do something about it, and I worked on it for several years as a partner at a Phoenix law firm. But at a certain point, I realized that what I wanted to do was not going in the same direction as the firm. So I continued to do the work until about 2018 at the firm, which is when I resigned to do this work full time. So, you know, the main goal is to get the United States Supreme Court to declare prison privatization a violation of the US Constitution. So we filed our first lawsuit against the Arizona Department of Corrections director in 2020. It's now before the Ninth Circuit, but we're preparing cases in other states to do the same work. And we're going to test some state constitutions as well. And I understand 4 states voted to amend their constitutions on Tuesday. Louisiana had some troublesome language. I guess they haven't passed it yet, but hopefully the voters will come back on that very same issue in 4 years. So that's kind of a rambling answer, Jack. I hope that's what you were looking for.
Jack, can I give a footnote to John's comment, which is that we know that people of color are disproportionately in prison across the country, way disproportionately. At the same time, it's important to understand that private prisons commodify people who are not people of color as well. And that historically, except in the Western Hemisphere, slavery has never been about race. It's always been about turning people who are conveniently available into commodities. And so, in fact, what the private prison is doing is opening up the potential to treat human beings as property to anyone in the United States. And that's worth understanding. This is not just about people of color. It's about everybody in the United States. And I think that's why there's a chance that we will eventually convince people in the United States that this is simply wrong.
There was a question, Jack, if you don't mind me jumping in as well. There was a question you asked before I was linked in, but I was able to hear it. And you said, you asked why private prisons? Why, when most people who are incarcerated are in public facilities, and there are so many other issues needing reform in criminal justice, why focus on privatization? And my answers are, first of all, I view the profit incentive in the criminal justice system as a cancer, that it is a perverse incentive. You know, when the crime rate goes down, that's great for taxpayers and families and communities. When the crime rate goes down, that's bad for private prison business. That's a perverse incentive. And secondly, it's because a small group of people can have potentially a huge impact on this issue. And what I mean by that is most corrections cases are about the facts on the ground in particular facilities, not about the law. And there is a ton of resources put into those conditions cases, and they last for years and years just to get to judgment or consent decree, and just as many years afterwards in enforcement. What we're focused on is, what does the Constitution mean? And a smaller group of people can have a big impact on that issue by getting that issue before the right people. So that's why focusing on it, in addition to the reasons stated earlier, we just think it is a constitutional violation. There are plenty of other advocates that are using other avenues to oppose privatization, including President Biden's executive order, his first week in office, in which he directed the federal government to extract itself from these private prison contractual arrangements. But most people in private prisons are there through the states and through immigration and customs enforcement, and the executive order doesn't apply to that. So that's my answer. There's an opportunity to do something about this, and you have to start somewhere. So those are some of my reasons for why this.
Thank you, John. We'd like to get into those constitutional issues, certainly, but you just mentioned the contracts and the federal contracts, and we have a question, and that is asking if you can speak to the contractual relationships between the states and the private prisons. Do you know the sorts of terms that are included in these contracts, typical terms in these contracts? And what, if any, is the extent of governmental oversight?
Yes. So working backwards, the extent of governmental oversight is always going to depend on who's in office in any particular agency at the time, and what their energy level is for dealing with corrections issues, and strong oversight. So that can vary greatly from one period of time to another. I'd like to define the term first, though, private prisons, if you haven't already. So when we're talking about private prisons, we're talking about the circumstance where the total operational control of a prison is turned over to a private corporation. We're not talking about the many other ways in which prisons, public and private, use private vendors for things like food, medical care, behavioral health, transportation, construction, maintenance, communications. We're not talking about all those other interests in mass incarceration. We're talking now about only operation, 24/7 control of a person's life when a private corporation runs a prison. The market is controlled. More than 90% of people are incarcerated in private prisons run by three particular corporations. The Geo Group and CoreCivic are publicly traded on the New York Stock Exchange. They are the two largest. And MTC, Management and Training Corporation, a privately held corporation, is the third. Between those three corporations, they are the fourth largest prison system in the country, and they pretty much have the market. There are some other players, but they pretty much have the market. The contracts are awarded through public procurement. Another way of saying that is public auction. So we see an analogy between slave auctions and awarding contracts to incarcerate so many lives, and then the payments under the contracts resemble healthcare. So I'm a healthcare attorney for the most part of my career. And the way we pay hospitals under Medicare and Medicaid, for example, is we give them per diem payments, a set amount per day, depending on what tier in a hospital a patient falls in. The same is true with the private prisons. They have different security levels. They contract for a certain number of lives. The contracts are for many years. So for in Arizona, for example, the contracts are for 10 years initially with 5-year renewal increments. And oh, by the way, the state of Arizona guarantees them 90 to 95% occupancy. So the dynamic of that is, number one, it's using up resources for incarceration instead of alternatives. Number two, if the crime rate goes down, no governor is going to want to explain to the taxpayers why they are paying for many empty cells in a private prison. So we're going to move people from the public facilities to the private in order to meet that occupational guarantee. In those contracts, the state is assigning or delegating its sovereign power in the most fundamental way over a person's life. That includes not only locking them up and telling them what time to get up and where to go to work, it also includes writing them up for any infractions and using force, including deadly force, in operating the prison. So this is truly a delegation of the state's sovereign power to a private corporation in the most fundamental way of controlling a person's liberty. And as I think Rob mentioned earlier, one way you enhance profits is you cut your costs. That can include programs that people have to participate in to get out early. And if you cut your programs and you don't offer those programs, people stay longer. And there are some academic reports out there, for example, in Mississippi, showing that people do spend as much as 10% more time in a private prison than in a public prison in Mississippi, after eliminating other variables. So yeah, the contracts run for years. They have occupational guarantees, and these corporations act like any other corporations. You want to make sure your friends are in the legislature and the governor's office. So they spend money on campaign contributions to make sure their friends get elected. And they spend millions on lobbyists to make sure that laws get in place that are going to be supportive of their business. So, for example, private prison operatives participated in ALEC, the American Legislative Exchange Council, when they were drafting model legislation that became 3 strikes, mandatory minimums, what's the third one? Truth in sentencing. So a lot of damage was done back then, and it helped sustain mass incarceration. The private prison industry may say we don't get involved in policy now. The damage was done. So that's a long answer to your question, what's in the contracts? But like any corporation, they want to sustain their business. They want more markets, which can mean getting into local government, like the city of Mesa in Arizona. They can go global. Private prisons are expanding in the United Kingdom, and they diversify if their main product is threatened, such as private probation and parole and ankle bracelets and bail bonds and the like.
Jack, one other piece of this is that if you watched the last political election just a week ago, one of the main focuses for some candidates, mostly Republicans, is that we have a rising crime rate. And so if you are running for office to say, I want to reduce the crime rate, and your state has the contracts that John has just explained to us, the answer is, I really don't want to reduce the crime rate, because if I reduce the crime rate, then I'm stuck with these empty cells, which I have to fill by transferring from state prison to private prison, but I still have to run those state prisons, and it still costs the state money to run the state prisons, even if we have reduced the number of prisoners in them. And I still have to pay the prison guards, even though it's less efficient, so that it's a vicious cycle in which, while on one hand, a politician says, I want to reduce the crime rate, the reality is, no, you don't. Especially, by the way, if your campaign is supported by private prisons.
I don't know if Rob is able to do this now. Rob, is it possible to show the two slides, the SEC filing and the Laura Sullivan article? What I'm asking is this. So I mentioned earlier that Geo Group and, let's see, where is it? There we go. So Geo Group and CoreCivic are publicly traded corporations. So they're required to file K-1s with the SEC. And in it, they have to include in their statements some safe harbor provisions. This is from CCA, rebranded as CoreCivic in 2017. This is from their annual report, and it appears in their annual reports just about every year. And, you know, it's as clear a statement as you can get. The demand for our facilities and services could be adversely affected by the relaxation of enforcement, leniency, etc., changes in sentencing practices. So, you know, the conflict with liberty is stated right there in the corporate minutes, and they act in accordance with that. And Rob, let me see if I can go to the Sullivan article. I don't know if I can find it. The point I wanted to make here is, so in 2010, Arizona's legislature and governor enacted Senate Bill 1070, which, to be blunt, was a law to round up people with brown skin. And most of the law was struck down by the United States Supreme Court. But it was pretty much racial profiling. And NPR's Laura Sullivan did a piece on who the heck was behind this law getting passed. And as you can see from this just summary from the article, it was the private prison industry that donated to almost all of the people that signed on to that law, including the governor. So, you know, like any other corporation, once you're in business, you want to sustain and you want to grow. And when you're in the business of incarcerating people, well, your growth is more incarceration. We just think we've created a really bad idea. And that goes back, Jack, to the fundamental question you asked at the beginning. Why privatization? Why are we focused on this? Well, we just went through that great recession, and, you know, the phrase too big to fail when we talked about bailing out the banks. Well, this industry doesn't have the deep root support. But there can come a time when our justice system becomes very dependent on the existence of these facilities. So we need to do something about it sooner rather than later.
Well, that's a very compelling definition of and description of private prisons and how they operate contractually. But let's constitutionalize the issue. What are, along with the delegation of executive authority to private entities, what are the broad range of constitutional implications that arise in looking at the issue of the reliance or use of private prisons?
So there's quite a bit, but you know, I'd love to bring Rob in to the discussion because of the recent Supreme Court decision in Dobbs and how that might affect our 14th Amendment arguments. Rob, is this a good time for you to?
Sure. And we can just broadly, I'll lay out the the sort of big scope of it. That non-delegation is one of them, obviously from the vesting clauses, the federal vesting clauses in the federal constitution, and basically every state has similar vesting clauses in their state constitution that basically say, you know, the executive power is vested in the governor or in the president, and everything else sort of flows from that. The legislative power is vested in a Congress, whether it's bicameral or whatever. So the vesting power says that the executive branch has to exercise executive power, and incarceration is clearly an executive power that we don't think can be delegated away, whether it has that sort of intelligible rule or not that you often see in the agency context. We think it's sort of a different question when it's a core government function like incarceration is. Of course, Professor Finkelman is going to talk about the 13th Amendment. There's very, very interesting theoretical stuff going on in the 13th Amendment with the punishment clause. I won't get into that too much because I think he's going to talk about that. And we can even maybe do his 13th Amendment stuff before I move into the 14th Amendment stuff, because I think some of what I'm going to say like pulls from what the 13th Amendment says and the timing of that. And then broadly speaking, there's two 14th Amendment questions with substantive due process and equal protection, and then also an 8th Amendment claim that is about ripping dignity away from a human to treat them like a commodity. And that often gets confused in 8th Amendment, you know, cruel and unusual punishment context. We often think about physical harm, right? And that's sort of what most of the 8th Amendment jurisprudence that we see is, you know, am I getting sufficient medical care? Are the prison guards physically beating me? But there is this undercurrent in 8th Amendment jurisprudence about dignity and what are the moral standards of a society that's evolving. And we think that even if it was, you know, when the Constitution was passed, that slavery was a thing, more and more states are moving away from using private prisons because they see it as slavery. We just have really, and we haven't been successful with this as a country, but the commodification of human beings has been broadly rejected from a moral principle. So that's 8th Amendment argument. I'll let Professor Finkelman go into the deep part of the 13th Amendment first.
Well, the 13th Amendment issue is kind of almost obvious. That is, the essence of slavery is that you are a commodity, that you are bought and sold, or rented. And in this case, this is exactly what has happened, because the balance sheet, the ability of a corporation to sell more stock, to get loans from banks, to expand, the balance sheet of the private prison is based on its assets. And the only long-term assets that a private prison has is the number of bodies that is under contract to store for the state. So in fact, what the private prison is it's in the business of turning body counts into a financial asset. That's what slavery was all about. But by the way, when John brought suit in Arizona, one of the defenses was, and this is why I talked briefly about race earlier, one of the defenses was, well, this isn't racially based and therefore it's not slavery. And that's why I pointed out that slavery, while historically racially based in the US, doesn't have to be racially based. There were Roman slaves and Italian slaves in Rome. There were Greek slaves in Greece. There were white Europeans enslaved by the Nazis. There are white Russians enslaved by the Russian government in the Gulag. This goes on everywhere in the world. So the issue of slavery is not necessarily racially based, but it is based on the commodification of the person. And so this is a defense that is hard to explain to a court, because courts basically don't want to hear it, which is the other problem. There's been very little litigation under the 13th Amendment since it was ratified in 1865, because the legal system kind of says, well, we got rid of slavery, we don't need to talk about it. And so part of our burden is to explain to the courts why this is in fact a reintroduction of slavery, because it's a reintroduction of commodification. I want to say one thing about equal protection, and then I'll turn it back to Robert, and that is that a person who gets sent to jail or prison and gets put in a private prison has less equal protection than somebody who is in a publicly run prison. And so the very nature of the prison, which gets to, the transferring of power to the private prison, is violating the equal protection of the prisoner. And that again goes into the Eighth Amendment, which, is applied to the states incorporated through the 14th. So we have lots of constitutional issues, but they are not easy ones, I think, to explain to courts. But I'll let Rob pick it up from here.
Okay, thanks. And I think so. I want to think about this just really quickly. What is substantive due process? In case it's been a long time since con law or whatever, you have two parts of the due process clause. You have the sort of procedural due process and the substantive due process. Procedural due process, all about protecting the fairness, right, of every process that a government body applies to you, right? So is the hearing that you got, did you have sufficient counsel and stuff like that? We think on that side, that the fact that the jailer and in that sense it runs all the way up and down the corporate ladder has this vested financial interest means that every interaction, if you're in a private facility, every interaction you have with somebody is tainted by that profit motive, right? So all the way down from at the very beginning when they're designing the private facility, how do they set out the rooms? What do the cells look like? Because there's research on what works and what doesn't. So are they designing those cells in such a way to maximize rehabilitation or to minimize that and increase recidivism, right? And all the way down to the day-to-day interactions that you might have with a frontline private security guard who knows that their pension, their future job requires there to be prisoners there. And I think that's where you see things like in Mississippi, the 10% longer time being served there, largely because of the increased rate of disciplinary infractions. So that's procedural due process. Substantive due process, on the other hand, protects largely fundamental rights, right? And we're going through, I think, sort of an upheaval in substantive due process law right now with Dobbs, right? You had a big change in even though the opinion tries to minimize that. And I think that's one real question. Does Dobbs represent a real monumental change in substantive due process law? Or do we take the majority opinion author at their word because they said it wasn't, right? And if you read carefully through the opinion, they cabin it very carefully, say this is only about abortion. There's this countervailing interest at stake here because you have the life of the fetus at stake. And so don't read too much into this. We're not going to change, the rights of gay people. We're not going to change the adoption rights, all of that stuff. So if we take them at their word, that fundamental rights analysis is not going to change and that Dobbs just is this sort of narrow thing about abortion, then all the other stuff historically stays the same. If that's not true and they're being honest and there really is this upheaval, then the question is, what is the fundamental right at stake? And is it deeply rooted in American history? And is it essential? Is it an essential component of ordered liberty, right? And I'd like to dispense with the last one most quickly because I think there's very little question that reducing the freedom of somebody, converting them into a slave for the profit of somebody else, that is, that right is tied inherently to the concept of ordered liberty, right? There's what the Dobbs discussion goes into a lot of what is liberty. Does this privacy right fall under liberty? But I think there's little argument that being reduced to a slave counts as liberty. So that I think is the quickest one. And the more interesting question in my mind after Dobbs is, if we're looking at a right that is deeply rooted in American tradition and history, right? If you look at the analysis that they performed in Dobbs, they do two things. They, one, go back a long ways, right? They talk about the Magna Carta in some sense. They talk about British common law and trace that through the American system to some extent. And then they also talk about what has happened since the ratification of the 14th Amendment. And that is also an important component of that historical analysis. And so I think when you're talking about private prisons, and because it's tied so inherently to the 13th Amendment, I think the real question about substantive due process in this context is going to be, are we talking about the historical right before the 13th Amendment or after the 13th Amendment, in the interim between the 13th Amendment and now, right? Because of course, there's no question that slavery itself, right? Not the right not to be a slave, because it's certainly not. Slavery itself is part of the American tradition. It's just because of the way that we were formed, you know, especially in the South. But if there is this change, a watershed moment at the ratification of the 13th and 14th Amendments, and we're looking at the concept of a fundamental right deeply rooted in American tradition since the 14th Amendment and since the 13th Amendment, that marks a break in time, then I think there is a good argument that the right not to be treated like a slave is a fundamental right. And historically, we've seen a couple of different ways that people have tried to get around that right. You see convict leasing in the South, right? You see all of the sorts of redlining and the stuff that has really traditionally been racially driven to try to keep a certain group of people as a second-class citizen, right? And those things have happened in the United States, but they have been rooted out pretty quickly. And I think conceptualizing those activities as ways to skirt around that fundamental right really shows you how substantive due process can be used to implement the 13th Amendment in a way that's not simply chattel slavery, which, as Professor Finkelman was saying, a lot of people have in their mind this 13th Amendment thing as just being this chattel slavery that existed as it did in the United States. But it doesn't say that in the 13th Amendment. It says slavery, right? It says involuntary servitude and slavery, which is a broader statement, right? A lot of commentators and other justices have talked about the 13th Amendment as being an expression of freedom. And converting that into how modern substantive due process works, I think, is going to be the most important question. And it's going to be very interesting how courts apply this sort of modern post-Dobbs, post-Glucksberg analysis into what a fundamental right looks like, what that's rooted in American tradition and history looks like.
There's a fundamental question that I don't think was asked when we first went down the road of our current model of prison privatization, which, by the way, I think started with a private prison contract between CoreCivic and Kentucky back in 1983. And that question is, well, if we make mass incarceration really profitable for some, what can go wrong? Well, imagine you're sitting in a courtroom as a defendant in a criminal case, and somebody mentions to you, oh, by the way, the retirement pension plans of the judge, the prosecutor, the police witness, and your public defender are invested in CoreCivic and Geo Group. And so are the retirement pensions of almost all government workers. If you're the defendant in that situation, no matter how nominal it may be for any individual, how are you feeling about the system right now? And how is the appearance of that system looking to any other observer? About a year ago, I was invited by a professor at Notre Dame to give a talk to a bunch of people incarcerated in the Westville prison in Westville, Indiana. And I went through an exercise with them. I said, let's imagine for a moment that every one of you own shares of stock in a private prison corporation. And we're having our annual meeting right now to come up with our 5-year strategic plan of how we're going to sustain and grow our business. Let's start throwing some ideas on a blackboard. Well, this group listening right now to this discussion could come up with some pretty good ideas right away. How do we cut our costs? How do we get into more markets? How do we get our rates up? How do we influence public policy? And you can take those general brushstrokes and come up with all kinds of subcategories there that don't necessarily have anything to do with protecting the public. So, so in any event, I know we're going to have a time limit coming up on us. The one thing I do want to mention, if you don't mind, a self-promotion for a moment. Our website, abolishprivateprisons.org, contains a lot of information, including the court filings in our case that is now before the Ninth Circuit, and our Prison Cells podcast, season 1, all 10 episodes. And anyone can tune in if you're interested. Regarding the litigation, I mean, I'd like to toss it back to Paul for a moment, but we do raise the 13th Amendment claim in the case that putting people in private prisons does violate the prohibitions on slavery and involuntary servitude. And of course, the first question is, well, what is slavery? Most 13th Amendment case law concerns involuntary servitude. Does not concern slavery, it's involuntary servitude. And so what we don't have is a definition from the US Supreme Court of what is slavery. We do know that African slavery was the primary concern of the drafters of the 13th Amendment, but it was not limited to that. So what we have in our case, I'll just read you a couple of things that are in the papers in our court case. The US District Court in Phoenix, in dismissing our 13th Amendment claim, wrote, "This is a matter of first impression. Plaintiffs have not cited and the court has not located any authority for the proposition that confinement in a private prison violates the 13th Amendment's prohibition against slavery and involuntary servitude." Not surprising in a case of first impression. So what we've written in our opening brief, in part in response, is that incarceration as punishment for crime may be a condition of slavery is not novel. It is contemplated by the 13th Amendment text itself. And indeed, as Paul will know much better than I, in our history, being sentenced to slavery was a criminal court remedy. Freeman could be sentenced to slavery. A freed slave could be resentenced to slavery on conviction of a crime. So our argument has been essentially threefold under the 13th Amendment. Number one, that the prohibition on slavery is absolute, that the punishment clause exception modifies involuntary servitude and not slavery. That is hardly the conventional interpretation of what we think is an ambiguous clause. And in fact, if I can just quote very briefly, Justice Harlan wrote his dissent in Plessy versus Ferguson in 1896. The next year, he wrote a dissent in a case called Robertson versus Baldwin. It had to do with a private ship captain throwing some sailors in the brig and making them work for free for the rest of the voyage when they tried to quit. They filed a 13th Amendment claim that was denied by the Supreme Court, but Harlan wrote, "Slavery exists whenever the law recognizes a right of property in a human being, but slavery cannot exist in any form in the United States. The 13th Amendment uprooted slavery as it once existed in this country and destroyed all of its badges and incidents. It established freedom for all." What Harlan was saying was the prohibition on slavery is absolute. Now, he said that without a recitation of authority, but that's our position A. If the exception clause permits slavery as punishment for crime, we argue, yeah, but it doesn't permit private punishment. The punishment clause of the 13th Amendment empowers the government. And lastly, we say if you're going to enslave someone, then that has to be the sentence. So, so in any event, coming back to the threshold question, exactly what is slavery, and we typically think of it as labor. But clearly for the people being transported across the Atlantic and held in slave jails on both continents, they were not valuable to their custodians because of their labor. It was simply because they were assets. And we contend that having a person's body in a prison cell creates profit for prison corporations. The corporations use the term man day. The prison receives X dollars per day for every day the person is in their cell. It costs them Y dollars to provide custodianship, and Z is the profit, simply for having them in their cell.
John, can I jump in real quick? Because there's a couple of questions.
Please.
Okay. So Mark, I hear your point about the past of English workhouses, and I think Paul and I have both mentioned some other previous sort of slavery-like things that have happened historically. And I think that's why it's important to note how that historical right is going to look when there's a 13th Amendment that happens that breaks that chain. And the other thing I think that's important in the Dobbs analysis is I think it's going to become clear how courts actually apply this analysis, but I see it as maybe the second step, or maybe it's the third step, depending on how you read it. But the other option for something to be a fundamental right, if it's not deeply rooted in American tradition and essential components of ordered liberty, the other option is if it's part of another broadly entrenched right? So I think that's the second or third step, or however you want to talk about it. The fact that it is so intimately connected to the 13th Amendment means that maybe it doesn't have to have the unbroken tradition back to the Magna Carta. And then I also see a question from Leslie about tactics to prevent new private prisons. It's not an area that we at Abolish Private Prisons have worked on specifically, but we did work with a group that I think was in Alabama. John, you might correct me on that. That is a grassroots organization that had a lot of success fighting a mega private prison that was going to be built. So if you want to reach out to us, we might be able to put you in contact with a group that specifically has some sort of like grassroots experience and how that can work, on a community level, sort of a community organizing level.
There's another advocacy tactic that students have used, and that is to approach their university boards of trustees to get them to divest their pension funds from private prison corporations. So the students at the University of Columbia were the first I was aware of that were successful. The first year they went to the board, they were turned away. The second year they were successful. Students in the University of California system were able to accomplish the same. New York state has withdrawn its pensions from the private prison industry. So there are other ways to go about it as well. The American Friends Service Committee, a Quaker group, filed a lawsuit back in 2012, 2013 to stop the construction of a private prison in Arizona, arguing there was no need for a new facility. The facility was never built, even though their lawsuit was ultimately dismissed.
Let me just chime in on the slavery issue, because of course what John said is absolutely correct, that slavery is not essentially about labor. The history of the world is the history of people working for other people, sometimes under unpleasant conditions. And the difference is that slavery is about the 24/7 control of the body of a person, of the whole person, and the ownership of that person, the ability to transfer that person to somebody else at any given moment. And that it can be slavery for a lifetime, it can be slavery for a shorter period of time, but the aspect of it is always about the literally turning the body into a commodity. And that's the difference between incarcerating somebody in a prison. And by the way, this is why I think the English workhouse doesn't help the private prison industry, because the English workhouse was always run by the government. And so the government said, we are incarcerating you in a jail and we're sending you to work every day. And we're sending you to work every day. In part, we can argue about whether this was a reality, but the theory was that we're sending you to work because we need to teach you to work so that when you get out of prison, you'll know how to work. Private prisons aren't interested in what happens to you when you get out, because they don't want you to get out. And if you do get out, private prisons want you to not have any skills, because then you can go back to a life of crime because it's all you know, and you'll end up back in the private prison. The private prison makes money for you. So all of this is about what the meaning of the 13th Amendment is. And as I said, and both Robert and John have said it as well, the jurisprudence on what the meaning of slavery is very, very narrow. It's very slim, because there hasn't been a lot of litigation on what slavery means. There are, however, some cases which deals with the badges of slavery. So, for example, restrictive covenants were declared unconstitutional on the grounds that slaves could not own property. And therefore, a restrictive covenant which prevents an African American from buying property is a badge of slavery. And that badge of slavery makes them unenforceable in an American court. And so that's one use of the 13th Amendment. So we have to be very creative, and really the trick is to educate the court about slavery. If we get into court, we will be able to educate the judges about what slavery is all about and why the 13th Amendment prevents turning human beings into commodities for the benefit of a private corporation. By the way, that doesn't mean that the state-run prisons can't still have a prison farm or a furniture factory or some other kind of factory. There's one of the New York State prisons makes socks, for example, but that's not commodifying the prisoner. That's actually giving the prisoner a job where they are learning to do something and getting very small amounts of money, but getting small amounts of payment for what they're doing. So that's the 13th Amendment trick, and it is not an easy it's not an easy education. I put in the chat a citation to an article that I co-wrote with a very distinguished scholar of world slavery, Seymour Drescher, in Michigan State Law Review, where I set out in that article about a dozen aspects of how you define what slavery is, if anybody wants to read it.
I'd like to address Leslie's question in the chat, suggesting any tactics. There are 5 states that have passed state laws that prohibit private prisons and jails and juvenile detention centers. And last year, we submitted a petition to the American Bar Association. They adopted a resolution calling for abolition in August of 2021. The legislative strategy can be difficult depending on what the politics of the locale are, but I think it's useful to find your allies. So if you were to take a look at our litigation, the court filings, you'll see that it's very unusual. We had 4 amicus briefs filed in support of our case upon the filing of our complaint. One of the amicus briefs was from a large group of faith-based organizations that see for-profit incarceration as unethical and immoral. Another group had to do with the rights of immigrants, because about 80% of immigrant detainees are being held in private facilities. Another from Latino justice, because of the impact of mass incarceration on people of color. And there are at least a couple of articles, academic articles, suggesting that impact is even more disproportionate in private facilities than public ones. So there are ways to figure out what kinds of alliances can you build that might help you go to public bodies that set public policy to either forbid the use of private prisons and jails, such as King County in Seattle did before it became a state law, to start your momentum. The one group I didn't mention that is virulently opposed to prison privatization are correctional officer unions and other law enforcement unions. So, of course, the strength of unions depends on what state you're in. But states like New York, Illinois, Washington, Iowa, I'm trying to think of what state did I leave out? California recently passed a law banning private prisons, although there's a pretty big exception in their law. So those are some of the other tactics, is just using the typical way to influence public policy through the voter initiative, for example. If the elected politicians won't end the industry in your locale, well, what about a voter initiative?
And John, two more questions in the chat that are sort of related, from Shelby and Kelsey. I think my quick answer to that is we're approaching 10:55. I think that to the extent that we're talking about 13th Amendment slavery and what's permissible under there, I think that trying to say that being paid less than minimum wage, whether it counts as slavery under a theoretical definition that Professor Finkelman has talked about, or sort of this like instinctual feeling of being forced to work for what amounts to zero pay is slavery in the popular conception. Ava DuVernay's otherwise excellent documentary 13th, I think, had this, from our perspective, a detrimental impact on how people think about slavery in prison, because the sort of conclusion of that documentary is that the 13th Amendment allows slavery in prisons. And we don't agree with that, obviously. And I think that some of that confusion can be about the less payment under minimum wage payment and whether that counts as slavery. That is a very, very, very challenging 13th Amendment claim, and has been rejected by a bunch of courts. Whether it counts as slavery or whether it's allowed under the punishment as an exception clause is, it's just tough. And then for Kelsey, this is something that we deal with when we're working with plaintiffs. There are some people who, for a variety of reasons, would prefer to be in a private facility, whether that's personal safety or whether because that particular private facility has a work program that they want to do. We would never, ever say that that person should not choose what's best for them individually, and having the dignity to be able to work is certainly something that somebody should be able to choose. And we, obviously we would advocate for paying people more than pennies on the hour and all of those things. But, that finding dignity wherever you can in an environment that's trying to strip it from you at every turn, I think is an important sort of, personal option that you can do.
One thing that I'd recommend that's Louisiana specific, if you haven't read it, I highly recommend Shane Bauer's book, American Prison. So Bauer went undercover, I use that word loosely, as a prison guard in a private prison in Wynne, Louisiana, and then wrote his book about his experiences there. He first wrote a series for Mother Jones magazine. But if you don't want to read the book, you can also listen to our Prison Cells podcast. I think it's our 5th or 6th episode. We interviewed Shane Bauer about his experience in Louisiana working in a private prison.
I know that we could continue this discussion for many more hours and still feel like we've got a lot to learn, a lot to discuss. However, we've come to the end of our time, and so I'd like to thank Paul Finkelman, John Dacey, and Robert Craig for joining us today and for presenting. It was a wonderful talk. I would urge you all to access the resources that they have placed in chat. and continue to educate yourself on this very important issue. We now have a break for a few minutes. The next session, the pay to stay statutes, will begin at 11:10. So take a brief break and we will see you in a few minutes.
Thank you, Jack.
Thank you, Paul.
Thank you all.
Thanks for having us.
Thank you, Robert. Thank you, John.
So long.
Welcome back, and thank you for joining us for our second panel of the morning. We've had some fantastic discussion, and I'm excited to see it continue. So just like last time, please continue to add questions to the chat anytime. We'll have time for questions at the end of this discussion, and we'll begin with questions from the chat before moving on with anyone with their virtual hand raised. So I'm excited to be able to introduce our next presenter, Brittany L. Deach. Professor Deach is an assistant professor of law at Capital University Law School, where she teaches criminal law and procedure. Her research focuses on the theory and practice of punishment, and her works often engage in analysis of whether certain practices in the criminal justice system advance or undermine their purported theoretical underpinnings. She's especially interested in the intersection of criminal punishment and poverty, and she's written on a variety of topics, including the ways in which parole conditions perpetuate a cycle of poverty and imprisonment, the application of death with dignity laws to prisoners serving life without parole sentences, and the constitutional flaws in criminal jury selection practices. Her scholarship has appeared in Georgetown Law Journal Online, Alabama Law Review, William and Mary Bill of Rights Journal, University of Chicago Law Review, and the Criminal Law Bulletin. Professor Deach's presentation today is about pay-to-stay private prisons. I was lucky enough to present on a panel with Professor Deach over the summer, and I'm very enthusiastic about her scholarship. I'm excited to hear what she has to say today. Professor Deach.
Thank you so much for that introduction. I'm really excited to participate in this symposium and to share my work on private prisons and pay-to-stay statutes. So I generally write and teach in the criminal law and procedure world, and I especially focus on punishment. I'm working on a project on pay-to-stay statutes, and while I was working on this paper, I had this sort of aha moment where I started thinking about private prisons, and then sort of away I went, where I decided I wanted to really explore the intersection of these two seemingly disparate issues within the system. I'm going to try to share my screen, and hopefully it works the way that I want it to. Fingers crossed. Are you able to see my slides? Okay, great. I think I made it worse on my end. Hang on, sorry. I guess I'm out of practice. I didn't realize I was out of practice with this. I have multiple screens going, and so that's what's going on here.
One thing that might help is you could drag from one screen to the other. Oh, never mind. Yep.
Yeah,
Wait,
that's
actually,
what I had to do. And I had to like yeah, okay. All right. So in this presentation, I'm going to cover a couple of basic, issues. I'll start with some background on private prisons and on pay-to-stay statutes. Then I'll discuss some of the problems that I've identified that arise when these two practices are combined. Then I'll propose a solution to the identified problems, and it may not be surprising. I view this solution as being abolition of both pay-to-stay statutes and private prisons. So starting with some background on private prisons, and I know that we got a lot out of our earlier panel, so I'll keep this pretty short. So private prisons exist in their modern form because, in part, at least, mass incarceration is expensive. As prison populations boomed, corrections expenditures also grew. So states were seeking creative solutions to mitigate those costs. So what fueled private prisons initially was this desire, or perhaps need, of states to figure out a more cost-effective way to manage their prison systems. So what the federal government and states that have entered into contracts with private prison corporations had hoped for, at least, was reduced cost of confinement. As the panel earlier had indicated, Whether those reduced costs were actually achieved is a big question mark. The private prison industry is by and large an oligopoly where there are three big players who dominate the marketplace. There have been a lot of studies on whether private prisons in their current form have actually worked to mitigate incarceration costs. So far, the studies have been inconsistent and a bit unreliable. So in that the data is a little unclear. So the information that we have is a little unclear. There's not really a clear financial advantage of private prisons. Some argue that any ostensible cost savings to the state are merely illusory. For one, some point out that private prisons might cost more than state-run facilities because the for-profit entities require governmental oversight that costs the government money that's not accounted for in the calculations. If the calculations are only showing the per prisoner costs that's reflected in the contract between the prison corporation and the government, what's omitted from the data are the regulatory costs that the government incurs while overseeing the private prison's compliance with their obligations to the government. Some also argue that any cost savings that seem to be there are merely illusory because the cost comparisons don't account for the costs of the respective needs of the prison populations in the private versus government-run prisons. Private prisons often restrict their inmate intake to those prisoners who are healthy, young, and have fewer psychiatric needs. Obviously, these restricted intakes mean that the populations that they're actually housing generally cost less than the populations of those in government-run facilities. Others also argue that cost savings are illusory because the private prisons don't actually save taxpayers money. That money is just converted to corporate profits for the incarcerating entity. So the data that we have to measure the cost efficacy of private prisons compared with state-run prisons is incomplete, and it's a little hard to have a perfect view of, a perfect conclusion or a perfect result. But all that to say, nevertheless, cost savings are the justification that the states use for private prisons. And it's a popular justification in that there are 26 states and the federal government who use private prisons to house a portion of their incarcerated populations. The most recent data from 2020 shows that there are about 100,000 people housed in private prisons, which represents 8% of the total US prison population. It might not seem like a lot, 8%, but it is only in about half of the states that contract with private prisons. Some states rely on private prisons to house a third or a half of their incarcerated populations. So that's kind of the relevant background on private prisons. Obviously, there's a lot more to say, and a lot of it has, fortunately for me, already been discussed. So next is background on pay-to-stay statutes. So pay-to-stay statutes exist in 49 states. They have some form of pay-to-stay statute. A pay-to-stay statute is sometimes referred to as an inmate reimbursement statute or a prisoner reimbursement statute by proponents. And what it does is it requires the incarcerated person to reimburse the state for the costs of their incarceration. So some statutes are very broad and allow the state to seize any assets or any income or anything during the period of incarceration and beyond, even after the inmate's release. It's just a debt that they owe to the state, until it's collected. States in these jurisdictions or states that have these broad statutes have done things like filing notice in probate court to intercept any inheritances that are going towards a formerly incarcerated person. They'll garnish wages. they'll file liens on any property that the person acquires, and they have really broad power in how they get their money back. So these states allow for seizure of property up to the amount of the cost of incarceration. They often calculate the cost by taking the total amount of annual corrections expenditures and applying a per diem per capita rate to find, this person owes X amount. Other states have limited statutes where they can only seek reimbursement for certain expenses like medical expenses, haircuts, things like that, transportation, or they can only seek reimbursement from certain sources like prisoners' wages, or they can only seek reimbursement within a certain number of years after release. So it's like they can take whatever to get to that total, but after 2 years or whatever, it's they can't, collect anymore. So why do states have pay-to-stay statutes? What justifies these statutes is exactly the same thing that justifies or purports to justify private prisons, and that's cost savings. Again, mass incarceration is expensive, and states try to get creative to try mitigating those costs. So these statutes are intended to shift the costs and the burdens of incarceration from the taxpayer to what the states call the user. So they try to convert incarceration expenditures into user fees. So the proliferation of these statutes tracks exactly with mass incarceration trends, which, like the panel earlier said, tracks exactly with private prison trends. So next, there's this clear overlap. So, 49 states have pay-to-stay statutes, and private prisons are in like 26 states. So there's clearly a lot of overlap. The overlap is really apparent in every state except Hawaii, which is a state that does not have a pay-to-stay statute. And Hawaii houses 36% of its incarcerated population in private prisons. So the problems that I identify in this paper apply to every state that has both pay-to-stay statutes and uses private prisons. But the problems are most significant in the states that have the broadest pay-to-stay statutes and have private prisons. These are, Arizona, where 19% of the incarcerated population is in private prisons, Florida, 13%, Oklahoma, 21%, Tennessee, 31%. So this is where the problems that I identify in this paper are most significantly implicated. So there are 3 big problems that I discuss when a state has a pay-to-stay statute and uses private prisons to house its incarcerated populations. First, there's an issue of taxpayer exclusion. Second, there's an issue with the structural scheme by its nature. And third, there's a practical issue of counterproductiveness. It doesn't satisfy the goals of our system. So starting, I'll address each one in turn. So starting with taxpayer exclusion. Taxpayer exclusion is a problem with either policy on its own. So it's a problem when you're using private prisons, and it's a problem when a state uses pay-to-stay statutes. But it's an amplified problem when the two are combined. One important feature of our criminal justice system is its expressive function. So the idea here is that when an individual is punished, society as a whole is expressing its condemnation of the criminal acts and expressing its view of the individual's blameworthiness. So punishment is viewed through this lens as the device that's used to express society's attitudes or resentments towards its members. So when you have a pay-to-stay statute, what that does is it excludes society from funding the punishment. So instead of the taxpayers having skin in the game, the individual is paying for their own incarceration. And this undermines that expressive function of punishment because it strips society of its stake in the punishment. Society has the right and the privilege and the responsibility of paying for the punishments that it renders, it issues. So clearly this is a privilege and a right and a responsibility that taxpayers might prefer not to have. They might not particularly want this right, but keeping the costs of punishment with the taxpayer is an important reflection of the citizen's role in the criminal justice system. So this unpleasant right to bear the costs of incarceration really respects society's voice in the punishment process. So when the prisoner is paying for the costs of their own incarceration, it additionally raises this question of whether the punishment itself can even be justified under traditional notions or theories or justifications of punishment, which are predicated on this notion that punishment is inflicted upon the guilty by society. So in a similar vein, with respect to private prisons, when a private entity is administering the punishment itself, society is similarly excluded from that process. State actors regulate and oversee the prison's operations to some degree, but the state isn't engaging in the day-to-day administration of punishment. The state is just, delegating it out to some private entity to handle. So when you take these together, society generally and taxpayers specifically are excluded from both the funding and the administration of justice, of punishment, in a way that undermines the democratic process and this expressive function of punishment. So that's problem one. Problem two is implicated by the combination of pay to stay and private prisons in the structural scheme as it exists. So it's more of a kind of structural problem. The state essentially is entering into this contract with this for-profit prison entity. And through this contract, the state is obligating itself to pay for the costs of housing and maintaining inmates. But meanwhile, through its statutes, the states have required the inmates to reimburse the state for those same costs, either to the full extent in the case of a pay to stay statute that's very broad, or to some narrower extent in states with limited pay to stay statutes, like, medical care or transportation or things like that. But in setting up the scheme in this way, what the state's doing is creating a situation where it's both the beneficiary and the benefactor. It's obligating the incarcerated person to pay for all of the costs that the state has assumed under this contract with this private corporation. This is especially problematic if private prisons are, actually more costly than the state-run facilities, and the private prison entity is deriving a profit from this arrangement. Under those circumstances, the incarcerated person is mandated through the state statute to create a corporate surplus for one of these corporations that's existing in an oligopolistic marketplace. This is inconsistent with the ostensible goal of shifting costs of incarceration from taxpayers to users, because when the state is actually using its statutory scheme to achieve the practical outcome of creating a profit for one of three big corporations, that's not the same as offsetting the costs of incarceration or reimbursing taxpayers. That's obligating the incarcerated person or formerly incarcerated person to ensure corporate surplus for one of these three big companies. But even if it's the case that it is cheaper, so even if there's a way where perhaps private prisons, are less costly, it's still problematic because the state is basically shirking its contractual burdens while still reaping all of the benefits. The state in this scheme gets to have its cake and eat it too, in a sense. It's contracted away its obligation to incarcerate the person, and it's statutorily entitled itself to reimbursement for the costs of that contract. So the state has voluntarily assumed certain obligations under the contract, and with a statute, it prevents itself from actually having to bear those burdens. The state doesn't have to administer the punishment, and it also, if the statutes are used, it also doesn't have to fund the punishment. So the state also, an additional issue here is that the state is controlling every decision along the way. The state's controlling the charges, the state's controlling the plea arrangements, the conditions of the prisons, the sentencing, the pay to stay calculations, the arrangement with the private prisons. The state is in total control all the way, from beginning to end. And it's not like the prisoner gets much of a choice. People aren't advised, for example, of their pay to stay obligations at the time of sentencing, or when they're entering into a plea. They're often, as a practical matter, they're often surprised with a bill or with money being taken out of their inmate trust accounts. It's not understood as being part of the deal that a person has voluntarily assumed. So pay to stay is generally a heavy-handed practice, but when it's done to benefit a for-profit entity, it's doubly problematic. It just compounds the problem. The third issue that I identify has to do with the counterproductiveness. So the combination of pay to stay statutes and private prisons is counterproductive with respect to the overarching goals of our criminal justice system. So burdening incarcerated and formerly incarcerated people with financial obligations means that the state is trapping these people in a cycle of poverty. Poverty is known to be criminogenic. So what this does is it promotes recidivism. It increases the affected people's likelihood of reincarceration. It increases their likelihood of being stuck in this cycle between poverty and prison. Incarcerated and formerly incarcerated people already experience very high rates of poverty and very low earning capacities. So adding debt to their difficult situations through pay to stay statutes inhibits the reentry efforts in a way that really can't be overstated. The data is jarring. So this is generally true of any legal financial obligation that's imposed on an incarcerated or formerly incarcerated person, but pay to stay statutes lead to enormous debts that in some cases can be affecting the person for the rest of their life. At least other legal financial obligations are, and then there's another issue with respect to the overlap with private prisons, and that's that when we're talking about other legal financial obligations, those at least can be shown to go back into the state or county coffers to promote public projects or something like that. But in this case, they could arguably be viewed as like paying a debt to society. But when there's a private prison benefiting from the arrangement, it's really just channeling the money to the corporation to incarcerate more people and continue the cycle. So it really benefits the private prisons and no one else. Society doesn't benefit from that. And as the earlier panel discussed as well, the private prisons themselves are perversely incentivized to promote recidivism. So adding the further exploitation on the people in these facilities really just compounds these perverse incentives further. And all of this, everything I've talked about so far sets aside the just indignity of the incarcerated person being made to pay room and board for their incarceration. And that's really a whole other issue, you know, on its own. So those are the three problems that I'm exploring. And as far as a solution, the only solution I see for the problems of taxpayer exclusion, the structural issues, and the counterproductiveness is simply to abolish both practices. It might be that the state just needs to find another way to avoid to fund its carceral system, either through raising taxes or preferably through revising its criminal codes and sentencing schemes to try mitigating mass incarceration instead of just focusing on mitigating the costs of mass incarceration. Individually, pay to stay and private prisons contribute to each of these three problems. But when they're combined, the problems are just amplified in this way that is, you know, truly untenable and completely counter to the ideals or the goals of our system. That's all I have for this part. Thank you so much again for letting me share my work. I'm looking forward to hearing your thoughts.
Thank you, Professor Deitch. So we do actually have a couple of questions in the chat already for you. I think the first one came up a while ago, so it might be a little bit out of context. And then there's one that just popped up a little bit more recently.
Okay. Not the decisions by elected officials to delegate a function. Okay, so to answer this first question, yes, so the decisions by elected officials to okay, so I guess the question is it taxpayer exclusion if there's elected officials who are making the decision to delegate a function to a private provider? So here, and this is a part that I, you know, sort of glossed over to try not to, you know, duplicate or be redundant with the previous panel, but the big issue is the scope of delegating authority away. So this is the sort of so incarceration is exactly the sort of government function that the government needs to do, and so delegating that away is much broader than hiring a contractor to, you know, build a road or build a building. So that's, you know, one problem. The other problem relates to kind of theoretical underpinnings of punishment, which is that there's this expressive function that's specific for punishment. It's specifically necessary that for a punishment to be justified, it should be performed by society, by the state, and it's not something that should be delegated out. So those are the two kind of answers to that, and I did skim past the delegation of duty issue. The private prison were state controlled. Yes, so the private prison, okay, so the question is whether the issue, let me see if I can go back, is whether the structural scheme issues that I identify are specifically I guess if it's specific to private prisons. So yes, the state does control every decision along the way. The problem that I identify is that the state is controlling every decision along the way and then sending the bill for those decisions to the incarcerated person. And when there's private prisons involved, those decisions that the state is making, those decisions serve to benefit these like private corporations. So there's I guess I can explain further that there's the argument, I guess, in favor of pay to stay statutes is, well, there's no problem because that's just what you get when you commit a crime, and the incarcerated person made the bad decision of committing a crime. So this is more my response to that, which is that, even if they choose to commit the crime, every other decision after that point is dictated by the state in a way that impacts the calculus for what they owe. And it's a surprise. It's not an informed sort of user fee the way that like going to get your driver's license or something is.
And I don't mean to cut us off, but we actually do need to wrap things up to get to our next panel. Yes.
Wow, this time flies. Sorry. Okay.
Well, I really appreciate your work here. And I know for the answer to the second question, I think you can maybe post a link into the chat if your former publication has been published, right? Because I know that'll answer some of those questions for Kelsey Jenkins. But thank you again, Professor Deach, for all of this. We really appreciate your taking the time to spend with us, and we'll take a very, very brief break before our next presentation.
Thank you so much for having me. Thanks.
All right, thank you. It is my great pleasure to introduce our next presenter as well. Professor Stevie Leahy, and I hope I'm getting everything right. And I'm very honored to present her. Professor Leahy teaches in the first year legal skills and social context program at Northeastern Law. Within her legal skills and social context program, Professor Leahy has collaborated with numerous social justice organizations. In connection with her work as the Center for Public Interest Advocacy and Collaboration resident fellow, Professor Leahy's current projects focus on the cradle to prison pipeline and juvenile justice. She'll speak with us today about juvenile sentencing and Jones versus Mississippi, a decision that, as she will discuss, will widen disparities in juvenile sentencing. Professor Leahy.
Thank you so much for that introduction. Welcome, and thank you for having me. It's just really been a pleasure to hear from such a fantastic cross-section of individuals today. I feel like I've very much learned quite a bit. My presentation is going to take a little bit of a different turn. I'm here to talk to you about the 2021 Jones versus Mississippi Supreme Court case and my work at the center that Susan mentioned, which is called CPAC, and the work that we do on the cradle to prison pipeline. And this talk represents my work in progress, which is a 4-part article. And if you'll just bear with me, I'm going to share my screen with you. Hopefully I can do so in a way that is error-free. There we go. Fantastic. So part 1 of my article, I'm going to be describing the history behind juvenile sentencing that is relevant to life without parole. And you are going to hear me use either the acronym LWOP or JLWOP, which just stands for juvenile life without parole. It's just a little bit of a shorthand, so I don't have to take all that time to say all those words every single time. This first section of the article highlights the departure that we're seeing at the federal level from the positive trajectory of increased protections for juveniles. That departure was found in the 2021 Jones decision. Part 2 of my article gives some jurisdiction-specific illustrations of how disparities in sentencing are playing out nationally. Part 3 describes the evolving understanding of neuroscience and the need for special treatment of not just those under that bright line of 18, which is currently how most places define a juvenile, but also emerging adults up through age 25. And finally, part 4 describes how our work on developing a sentencing bench card that's in line with the most recent science can hopefully make sentencing a little bit more equitable. And while I have not been focused specifically on Louisiana in my research, I have incorporated some Louisiana-specific examples into my talk today to underscore the concept of justice by geography. So my research work with CPAC, which is the center that I mentioned earlier, really builds on a project that the center has been having ongoing for the past couple years. And that project has been to map the cradle to prison pipeline. And you can see that up here on the slide now. It was actually so large that I had to cut it in half. And I realized some of these things are still very tiny and hard to read. But if you follow the QR code in the upper right corner, it will take you to the website where this is posted in a way that's a little bit more accessible. But you can see all of the entry points that we've mapped out on this pipeline. We have pervasive poverty, housing inequity, population health, child welfare system, education, and then juvenile justice here, down here on the bottom right, funneling folks into incarceration. And that's really what the cradle to prison pipeline is. It's this web of legal and social systems rooted in structural racism that begins before birth and persists through the teen years. And our research shows that it diverts youth, and especially Black youth and youth of color, towards incarceration. So this is what CPAC has been working on. We did not create the idea of the cradle to prison pipeline. That credit goes to the Children's Defense Fund, established by Marian Wright Edelman. But through our work at CPAC and Northeastern, we're hoping to just amplify that data transparency. And so we have an interdisciplinary approach to policy initiatives and research that is hoping to ameliorate the diversion of Black youth into the carceral system and in general youth across the board. So I wanted to start here because this is where my research started. This is where my interest in Jones started. And I'm actually in the fortunate position that my independent research also overlaps with the program that I teach in, which is called Legal Skills in Social Context. And so I'm able to collaborate with social justice organizations in Boston and nationally that are also interested in these topics, and get first years really excited about an issue that is grounded in social justice as, you know, a cornerstone of their first year of legal education. So with that background, I want to dive into the Supreme Court precedent, the juvenile life without parole cases. And we really can't start with Jones. Jones is a 2021 decision, but we have to look at 4 other cases that came before Jones because they are just foundational to understanding. So in 2005, we have the Roper v. Simmons case, and you can see the composition of the bench here up on the slide. It took us until 2005 to ban the death penalty for defendants under the age of 18. Prior to this, 16 and 17-year-olds were eligible for capital punishment in some states. So I'm using the composition of the bench for all of these 4 cases because it's no surprise to anyone that the composition of the bench, the Supreme Court or any other bench, is going to impact outcome. And we'll really see that shifting as we're leading up to Jones. In a 5-4 opinion, Justice Kennedy, citing to standards of decency in the US and internationally, forbade under the 8th Amendment capital punishment for those under the age of 18. And I also want to emphasize, you know, citing to these national, international standards of decency is a trend that we see through these 4 cases. Our second case here is Graham versus Florida. So now that we are in the position where the US has banned execution, the court had to decide whether or not they were going to ban a sentence of LWOP for an offense committed by a juvenile that was not a homicide. Different composition of the bench here, as you can see, we're shifting a little bit. Another opinion from Justice Kennedy, and we have an outcome that is increasing protections for juveniles. So the 8th Amendment, once again, is going to prohibit states as a floor from giving a sentence of LWOP for a non-homicide crime. Once again, the court is citing to national and international standards. And they made a point to note that life without parole sentences for juveniles are very much like the death penalty. That brings us to case 3, which is perhaps prior to Jones, one of the most well-known cases in this space, and that is the 2012 Miller versus Alabama decision. We have a 5-4 decision again, so all of these decisions are very close. And Justice Kagan mandated, again, more protections for juveniles. So we're continuing on that trend. And we have some great language in this decision about how kids are just constitutionally different than adults for sentencing purposes. So this decision held that even though if you are under 18, you can still be sentenced to life without parole for a homicide, it cannot be a mandatory sentence. These mandatory penalties by their nature do not allow the sentencer to take into account age and all of the circumstances attendant to youth. And this decision gave us what is called the Miller factors. The Supreme Court here identified 5 factors that should be thought about when determining whether a juvenile should be sentenced to life without parole. That's age, family home environment, circumstances of the offense, the incapacities of youth within the legal system itself, and the heightened ability of a juvenile to be rehabilitated. So these are the 5 Miller factors, and you can see here a lot of connection back to that cradle to prison pipeline. The factors are attempting to pull in some of that information when assessing the appropriate penalty for a juvenile. And then finally, our 4th case, Montgomery versus Louisiana. This case basically said that the Miller prohibition on mandatory life without parole applied retroactively. It applied back beyond 2012. And, in connection with Louisiana specifically, at the center of this case was a man named Henry Montgomery. He was first sentenced to be executed in connection with a 1963 murder when he was 17. This was later modified to juvenile life without parole. And then after the Miller case, Henry got a chance to be resentenced, and he was resentenced to life with parole. And after unsuccessfully applying for parole numerous times in 2021, he actually was granted parole and released after decades in prison. So those are the 4 cases that are really essential to understanding Jones. And prior to Jones, Miller was the gold standard. However, we were still seeing a lot of disparities. And I have a map here to try and help visualize what happened at the state level in terms of how juvenile sentencing was playing out. Progress was really fractured in implementation. And this map is justice by geography. You have a lot of states that after Miller completely banned juvenile life without parole, either legislatively or judicially, which includes Massachusetts. We have some states that have gone even further and extended that prohibition up to age 20 or 25. So some states took that floor from Miller and drastically increased the protections. But as you can see from this map, even though federally the decisions were becoming more protective, a 17-year-old in Massachusetts post-Miller still faces drastically different consequences than a 17-year-old in many other states. So the justice and the sentence you receive were varying by where you were born and where you were sentenced. Mississippi and Louisiana, for example, still allowed life without parole as long as you had that so-called Miller hearing where they had those factors to be taken into consideration. So this is leading up to Jones in 2021. The Supreme Court has the opportunity to require a baseline for the states that are still sentencing kids to life without the possibility of parole. And before I get to Jones, I just wanted to kind of highlight Louisiana here, which continued to use life without parole sentencing for juveniles. And just like many other facets of the cradle to prison pipeline and birth penalties, research shows us that juveniles most impacted by these sentences are largely and increasingly people of color to a degree that is vastly disproportionate from overall population statistics. A 2005 study called A Report of the Phillips Black Project found that Black youth are twice as likely to receive a sentence of LWOP than their white peers. And Louisiana in particular has shown that to be the case, has a large population of people currently serving sentences they were handed as children, and in the past years has sentenced more children to jail WOP than any other state. There is hope on the horizon. There has been legislation introduced and people are pushing for change, but until that happens, these sentencing disparities at the national level are going to continue to widen. So here we are at Jones. We've been looking at Jones since it came out, and excuse me, here you can see the composition of the bench, and we get to a point where the Supreme Court has the ability to set some specific standards when it comes to imposing these very harsh sentences, but they declined to do so. So we have a decision here by Justice Kavanaugh. We have a very powerful dissent by Justice Sotomayor. And I just want to give a little bit of the story behind Brett Jones at the center of this case. He was 15 years old when he killed his grandfather 23 days after his birthday. He was initially sentenced to juvenile life without parole prior to the Miller case, but then was eligible to reapply, and he had his Miller hearings. And evidence presented at those hearings demonstrated so many of the issues that come into play early in the cradle to prison pipeline. And so many hit on so many of those Miller factors. You know, there was an extremely abusive home environment, both physically and emotionally. There was lack of access to resources, including medication, intergenerational violence, abuse, poverty. Brett Jones had his Miller hearing, and the Mississippi Supreme Court reissued his life without parole sentence. And Brett Jones asked the Supreme Court whether or not a sentencer is required to make a specific finding as to those Miller factors. So the Supreme Court could have said, yes, you've got to go through all those factors. We need that all on the record. You have to make it clear that youth was considered in a meaningful way. That's not what the Supreme Court did. Kavanaugh wrote that the sentencer does not need to specifically find any of those things that were discussed in Miller. The decision does not even require a sentencer to articulate a specific Miller rationale. The bar is just so low now that the sentencing judge only needs to understand that they had the discretion to consider Miller and that the judge made an individualized decision. So it's really consideration of youth in name only. And Jones is really a backslide. They had the opportunity, they did not take it. And this kind of discretion in the past with no record has led to extreme disparities. My students this year have been tracking Jones, and as of Tuesday, it's been cited in nearly 200 state court cases and 74 federal court cases. Drastic disparities with how judiciaries across the country are treating this. And we have little pockets of jurisdictional places that are more heavily citing to Jones than other. So this is going to be a continuation project where we see how Jones is playing out. And so in connection with Jones and in connection with those social justice projects that I mentioned, my students have been working with an organization called the Center for Law, Brain, and Behavior. And there's an individual there named Dr. Robert Kinscherf, who's an expert in this field. He's a PhD, JD, and he's testified in many cases related to the development of adolescent brains. So we're currently in year 2 of a collaborative project. And the goal of this organization, the goal of CLBB, is to put the most accurate and the most actionable neuroscience into the hands of judges, lawyers, policymakers, journalists, people who shape the practices of our legal system. And we're going to try and work to make that system more effective. So CLBB has recently produced a white paper, and that's just intended to facilitate more science-informed decision-making in these juvenile sentencing decisions. Excuse me. The white paper is based on the Miller case, and I actually thought that that was just ingenious from an organizational, structural way to set up their white paper, because they use those same 5 categories to organize their research. And the bottom line of the white paper is that this bright line standard that we have of using 18 does not make sense when you look at it through the lens of neuroscience. It should really be up through age 25 if we're thinking about what the rationale is behind drawing that line to determine who is a juvenile. So this paper was released post-Jones, but the goal is that this can be used as a vehicle for courts and legislatures to make decisions about juveniles more in line with the science. And so finally, my last slide here, my students are using this white paper to create a bench card. Bench cards are used in other spaces already, as you can see some examples up here on the slide. They vary in length and topic, and you can see these examples, but the principle is it will provide guidance for a sentencer to walk through those 5 Miller factors when it is considering a juvenile sentence, and look at age and immaturity, to look at family home environment, to look at peer influence, to look at understanding of legal proceedings, and then very importantly, to look at a juvenile's greater potential for rehabilitation. So we actually have a meaningful consideration of youth in some of these decisions where it might matter for the juvenile. The white paper is very long. It's, near 150 pages. And so we think it unlikely that a sentencer is going to go through a 150-page document. So the idea was to give a shorter bench card, easily digested. Here's your decision tree. Let's make more meaningful decisions when we are sentencing you to a life sentence. And the Supreme Court has told us numerous times, youth are constitutionally different than adults. They are more capable of rehabilitation, and they need to be given that chance. And so while our nation is the only one that currently sentences youth to a life behind bars, we are going to continue to work at CPAC and at CLBB and Northeastern on sentencing and cradle to prison issues to get to a place where that is not the case anymore. So our hope is that a bench card based on the white paper can be a useful tool going forward as a vehicle for courts and legislators to make decisions about incarceration that are more in line with the science. That is my 4-part article in progress. And it was really, I had a lot of fun prepping for today, and I'm obviously very excited and enthusiastic about this work. And I just so appreciate the opportunity to share it with you all today.
Thank you very much, Professor Leahy. We already have a question. I think it's a fantastic question for you in the chat, if you don't mind responding to that question.
Yes. So would the proposal impact? So the way that we've seen the definition of juvenile be expanded has been done in a piecemeal way. It's been done in limited context. So I have not seen any state thus far who has extended the age across the board as a broad definitional change for the entire body of laws of that state. We have seen it limited to those sentencing decisions. And for example, there's a case in Massachusetts right now in the Superior Court that's on its way up to our highest court, where the judge has extended for sentencing purposes only for JLWOP up to age 20. So in Massachusetts, we are about to decide, is juvenile for sentencing purposes 18 and under, or is it 20 and under? And so it's been a much more limited shift when it comes to raising that bar.
Excellent. So has the research, I'm just going to sort of ask a follow-up question if you don't mind, and we can look to any more questions in the chat. Would the research suggest that we should be thinking a little bit more broader? I mean, I know this might be a little bit beyond your scope, but the neurological research, should we be looking at capacity to, for example, contract?
So the white paper talks a lot about juveniles when they're in a pressure situation and hot and cold decision making. So the white paper itself, I don't think is a resource that we would use to raise the age across the board in, for example, when you've had time to read and digest a contract and you're making that cold decision. It talks a lot about situations when youth are with a group of peers, where there's pressure, where there's not a lot of time to make decisions. And it also pulls in all of those factors that might have impacted the youth into a life of crime that the Cradle to Prison pipeline talks about. So the white paper is more focused on sentencing as well, and I don't think would be grounds to say, move up the voting age to 25. And And I don't think that I wouldn't be part of that push myself, but the white paper is definitely focused on those situations surrounding circumstances leading to juveniles becoming systems involved.
Fantastic. I'm going to pause for one moment for anyone to raise their hand and ask questions. You can raise your virtual hand using the reaction. Then, or you can post more in the chat. Okay, we have one from Shelby Terrell.
Juvenile offenders have been moved according to funding for local housing issues. Would your advocacy focus on constitutional legal advocacy? So I haven't been involved in a lot of funding of facilities research. There's a lot going on, and I apologize, I don't know specifically about that issue for Louisiana, but I know in Massachusetts, there's a big push in terms of decreasing funding for facilities and increasing funding for programming, diversion, reentry, things like that. But that's not something that my research has specifically covered for funding purposes. So I'm a little limited in that. Would you raise the drinking age to 25? Me personally, I might think about it. Yeah, that's an unofficial, non-legal, personal opinion there on raising the drinking age to 25. Again, Susan, thank you so much. This was a joy.
Yes, this is fantastic. So I think this is a great place to sort of wrap up. And I'd like to thank you once again. We're going to do closing remarks in just one moment, but I will virtually clap for you. And I'd like to thank you again for your work here. It's important work, and we're glad that you were able to share it with us.
Thanks so much.
All right, well, this concludes the third annual virtual symposium by the LSU Law Journal for Social Justice and Policy. Thank you again for joining us. I hope you found today's themes as thought-provoking and sometimes infuriating, as I did. I'd like to take a moment to reflect on some of the themes that have been discussed today. So we've talked several times about problems with profitability in the prison system, issues with monetizing incarceration and incentivizing imprisonment and mass incarceration, and the issues that come from involuntary servitude, whether they are forced labor or even just incentivized labor in a prison system that could profit from that labor. We've also seen some questions about who should pay for prison stays, and a really deep dive into what the role of the justice system is and who should bear the burden or potentially the privilege for paying for that. We've also seen a great conversation about vulnerable populations and the role that the state should have in considering the needs and vulnerabilities specific to juveniles and emerging adults. And as important as these themes are, and they are vitally important, they also implicate more fundamental policies and philosophies foundational to our conception of ourselves as a country and a society. I don't think it's an overstatement to say that the questions we ask about fairness in the prison system have wide-reaching implications for democracy and the rule of law. During our first panel with Paul Finkelman, Robert Craig, and John Dacey, the question was raised about whether money could influence not just who we jail, but what we consider to be crimes. I think this is an important question to ask about the function of law more generally, and I'm proud to support the work of our students at the LSU Law Journal for Social Justice and Policy as they investigate these themes. On behalf of the editorial board of the LSU Law Journal for Social Justice and Policy, I'd like to thank all of our attendees for coming to hear from our wonderful presenters this morning. Moreover, we would like to thank each of our presenters for their individual contributions to the symposium on the industrial prison complex system today. Paul Finkelman, John Dacey, Robert Craig, Brittany Deach, and Stevie Leahy. These are scholars and advocates on the front lines of one of the most pressing issues for equality in America. I'd like to personally thank you for devoting your time and resources to such important questions of justice. As the LSU Law Journal for Social Justice and Policy continues to grow, we ask that academic scholars in attendance today consider submitting their social justice and policy research to the journal for publication consideration. And as a reminder, for those attendees that need CLE credit, make sure to return the CLE either by email or mail it to the journal. And for any questions or concerns, please contact the emails displayed on the symposium website on the LSU Law website. And once again, thank you to all our presenters and the students and faculty who helped make this year's symposium possible.